Hello everyone, I'm George from Ireland. So carrying on my English law series and about contract law. So forgive me, I was rudely interrupted this morning. I was talking about terms of a contract. Uh, I went back to that case of Centro Vinicol Estates and Merchant Assessors Insurance Company, a 1983 case about when an offer was made, but those who were offering a certain rent, they accidentally said half the rent they intended to. But the offeree, those to whom the offer was made, they accepted that, and then the offeror said, "Oh my goodness, we're bound to an offer that it was a mistake," and so the offerors they took out legal action against this, but the court found that the offeree was right to accept it because it seemed like a realistic offer. What would a reasonable businessman think in this position? That's the objective standard. Might think that this was a reasonable offer, something considerably below market rate, but not just so ludicrous that it couldn't possibly be true. Um, and there's another case like that, Donani and Krasiansky, a 2011 case. Now, if you're mistaken as to the terms, that can be different, where the court holds that wouldn't be quite the same. So that's not really the objective approach. It's Hartog against Collins and Shields, a 1939 case. Um, so uh, Sometimes an offeree should have known that an offeror was mistaken as to what the terms were, and the offeree should have known. Again, the court will probably rule that there is no contract there, such as in Scriven Brothers and Hindley, a 1913 case. So we know that offers are made about in a contract, and then either accepted or rejected. And sometimes they're invitations to treat, which to come in and negotiate. That's what treat means in this case, not give you something for free as a treat. So an offer is when you intend that if the offer is accepted, that is legally binding. And so there's the celebrated case of Stora and Manchester City Council, 1974, where Manchester City Council they sent an offer to this chap to purchase his council house. All he needed to do was sign the form. They would have bound himself to the offer, which he did. Then Manchester City Council desperately attempted to backpedal and said, "No, no, 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 we didn't intend that to be an offer." Well, the court found no, it was crystal clear. You did. It's all there in black and white. It simply remained for him to sign, and that was the offer accepted. There was a contract. So the court found in favour of Stora, who was the claimant. Or there's indeed Gibson and Manchester City Council in 1979. And although it was the same city council, the form had changed, and so this was crucially different. In their letter to Gibson, they said, "We may be prepared to sell the house." And so Gibson said, "Yes, I accept." And that went to court. Well, Lord Denning said the words "may be prepared to sell" are fatal because it was introducing uncertainty. They were only going to consider it. They weren't definitely going to accept it. So that wasn't an offer. Um, all right. We have to have a statement of intention. So one party says that he intends to do something. That is not quite the same saying that he will do it. Intention is not quite definite. So Harris and Nickerson, 1873, turned upon that. So that he intended to sell items that didn't guarantee that he shall sell said items. A supply of information is not an offer. Okay, so an invitation to treat. For example, showing your goods in the window of your shop is an invitation to treat. It was Pharmaceutical Society and Boots in 1953, and the reason is that this is not an offer, it's just to come and take a look. Fisher and Bell, 1961, is the same, but then there's Thornton and Shoe Lane Parking, 1971, said that a display in a machine is saying you can park here for an hour for £3 or whatever. That is an offer, and once you put the money in, you've accepted the offer. Okay, so let me see. We could look at another case, which is Partridge and Crittenden, a 1968 case, and this is about bilateral contract. So a bilateral offer. So I offer you something, you offer me something, that's it. But then there can be a unilateral contract, such as Carlyle and Carbolic Smokeball, 1893, a very celebrated case where these people had this smoke ball, and if you had a cough or something like that, or a sneeze. They said if you buy it and breathe it in a few times, that will cure your cold, and if it doesn't, we'll pay you £100. And in their advertisement, they said we put £1,000 into a bank account because we're so confident that we're going to pay out. But if you do not satisfied, we'll pay you £100, which was a staggering sum in the 1890s. You can multiply by about 250 to get current values. And so Carlyle, she claimed that it hadn't cured her. She wrote in and said, I claim my reward. And Carlyle and Carbolic Smoke Ball said simply, this was a mere puff. It was just an advertising bit of hype, and it's not legally binding. It wasn't an offer, because, but the court found that no, it was an offer. It's a unilateral offer, and the other party didn't need to communicate acceptance. Simply by doing whatever that you asked them to do, by attempting to get it to cure them, that was them accepting the offer, so she can now get her reward, and indeed she did. Now, in European law, it's a little bit different. They said it would be a breach of consumer protection law in the EU if a consumer has not sold a product on advertised terms when he goes into a shop. That's a case about that. Trento Sviluppo Società con Responsabilità Limitata against Autorità Garante della Concorrenza e del Mercato, 2014. So it was a sort of Trento Development Limited, that's what it means in Italian, against the Authority to Guarantee Competition in the Market. Okay, so you can see the request for tenders, and that's an invitation to treat, as per Harvella Investments Limited against Royal Trust Company of Canada Limited, 1985. Let me see. So if you put out seeking tenders, that means you're going to at least consider all tenders that meet your criteria. That's as per Blackpool and Filed Aero Club Limited and Blackpool Borough Council, 1990. So an auctioneer can ask for bids, and the moment his hammer comes down, that's it, he's accepted that, provided they meet the reserve price. That's as in Warlow and Harrison, 1859, or indeed Barry and Davies, 2000. So there are more things to know about. So offers need to be communicated. Well, you can't accept an offer if you don't know about it, generally speaking. But sometimes people do things which would be accepting the offer, except they haven't even heard about the offer. So authorities are unclear on this. In Gibbons and Proctor, 1891, a policeman was allowed to recover an award for providing information, even though he provided that information not even knowing there was an award on offer. But another Commonwealth country took a different view. In R. and Clark, in 1927, that's an Australian case, that the bench held that you cannot assent to an offer if you have no knowledge of it. And ignorance of an offer is the same thing as never hearing it, or indeed of hearing about it but later forgetting about it. So there can also be cross offers. In Tin and Hoffman, 1873, when this person makes an offer, that makes an offer at the same time, they get to each other later, and you both accept at the same time about the same issue. Who prevails? That's very unclear. Okay, so acceptance of offer. So you then have to accept the offer. Usually you need to communicate this. So if you say thank you for the instructions, that doesn't mean that you're accepting it. That's as per Arcadis Consulting and AMEC, a 2016 case. So in Revale Independent LLC and Anatech International UK Limited, 2016, a draft agreement was accepted, and then people behaved in a way which indicated they'd accepted the offer, even though the agreement hadn't actually been signed, and the agreement specifically said we need a signature here. Any lawyer will tell you can accept a contract by conduct, not simply by signing. When you purchase an item in a shop, you don't sign anything. You've handed over the money. That's it. You've accepted the offer. The contract's made. Okay, so whether a contract is accepted or not is established objectively. So Brogden and Metropolitan Railway Company, 1877, an offer was accepted by performing the contract. Likewise, Claxton Engineering Services Limited, and Olaj ES Gazkoto KFT, a Hungarian company, continued to do business with its English interlocutor, despite the fact that the English company had rejected the proposal for arbitration in the Hungarian courts. And anyway, the Hungarian company's behaviour was regarded by an English court as acceptance of the offer. Okay, so if the offeree makes a counteroffer, then that vitiates the original offer. That's as per Hyde and Wrench, 1840. And so then the offeror has become the offeree. So let me see. If you ask for more information, this doesn't say yes or no to the original offer. Okay, so now the offeror could then vary the offer based on the request for information as per Stevenson, Jakes and Company against McLean, 1880. So there was a case called Butler Machine Tool Limited and XLO. So sometimes they're making offers back and forth, and it came out that the last shot wins the battle of the forms. Although Lord Denning was master of the rolls, he disagreed in that particular case. So within other cases like Tech Data, Internet Connections Limited, and Amphenol Limited, 2009, the Court of Appeal said that the traditional attitude, saying that you need to be sure about commercial contracts, prevails. Okay, what else should you know about? So anyway, some relationships don't count as contracts, but can't be viewed in that way. In the Euromed in 1975, about that New Zealand ship, Lord Wilberforce said that English law is committed to a strict and very particular doctrine of contract. But anyway, so sometimes it forces contracts into this almost artificial formula of offer and acceptance. But nevertheless, that's the way it is. There are occasions in which things can't be regarded as contracts. The President of the Methodist Conference and Preston, 2013, where Preston supposedly been offered to be a Methodist minister, but the court said this was too informal. That doesn't count as a contractual offer. Okay, so usually a contract cannot be accepted through silence, such as in Feldhaus and Brindley. By saying I'm doing nothing, that can't be an offer. Unless I hear from you by so and such a time, I'll assume you've accepted the offer. No. Now, there are exceptions. So long as this doesn't force the contract on the unwilling, silence can occasionally be an acceptance. So if you make an offer, you are allowed to retract that offer before it's accepted. And then what if you send the message accepting the offer by post? This is a little bit tricky. There was the postal acceptance rule. Sometimes the acceptance is received by a computer or a fax machine or something like that. That might be outside of business office hours, particularly in international trade, middle of the night in the United Kingdom. There was a case, Tenax Steamship Company, against owners of the motor vessel Brimner, in 1975. And in this case, it was about withdrawing a ship from a ship charter. So it said when a communication is received by an unmanned receptor, computer, answering machine, or something like that, then from the moment the machine is checked, the offer's been accepted, because the message might have been sent hours earlier, but it wasn't heard by anybody. So is that communicated or not? Not until it's actually received by the human checking it. The trouble is that human checking it might not necessarily pass the message on to the person who needs to know, to the manager, the CEO, or whoever. Okay, so now, so I talked about that need for acceptance, though again there's some exemptions. That's the tricky thing, all the exceptions in law. So acceptance needs to be brought to the offeror's intention. Sometimes the offeror might waive the need for communication. Carlyle against Carbolic Smoke Ball was said to be a case of that with the unilateral offer. The unilateral offer is there's no need for acceptance like that if you just advertise it to all the world. Now come back to the postal acceptance rule, because the contract law goes back many centuries. We didn't have the telephone until the late 19th century, or fax machines and so on, and computers until well into the late 20th century. So thinking about accepting by post, you send a letter. The moment when is the acceptance received? Is it the moment you send it? Is it the moment it's actually open in the post? Could be days, weeks even. So the court said it's accepted. The acceptance is received the moment it's posted. Seems ludicrous. There was even a case where something was posted, the letter was lost in the post. Nevertheless, the court ruled so what? It was still it was communicated the moment you sent it, even though they never received it. Don't know how they proved they sent it. Perhaps it was recorded delivery or something, or certificate of posting. But nevertheless, that is the rule. And there are exceptions, such as in cases, for example, Adams and Linsell, 1818, or Household Fire and Carriage Accident Insurance Company Limited and Grant, 1879. So that's the postal acceptance rule. So there's a risk that the post will be lost, and that's a risk that's put on the offeror. Let me see. It depends, though, if postal acceptance is reasonably contemplated by the parties. Now, as we have much more rapid means of communication, postal acceptance isn't that important anyway, not in most contracts. Sometimes that was the only practical means or even the fastest means of communication, such as in Henthorne and Fraser, 1892. So the risk of delay is on the offeror, but the risk of carelessness of the offeree is not, if somehow he fails to address it properly or something. L.J. Corbatis against Transgrain Shipping, BV, 2005. So the difficulty here is when a contract can be formed and the offeror isn't even aware that the contract's been formed. The offer is accepted. The offeror might have actually changed his mind, said, don't want to make that offer anymore, before the communication is actually received. So the offeror is now in breach of the contract. So, but anyway, because of technological advances, that doesn't really matter so much. Well, there was a case, Holwell Securities Limited and Hughes, 1874. And in this case, the postal acceptance rules didn't apply if the offeror intended to apply. There were telexes we used to use. We don't really use them anymore. Torres and Miles Far East Corporation, 1955. Brinket Beyond Limited and Stahl, 1982 are cases about these, about fax. Now, email is more or less instant, so courts don't want to extend the postal acceptance rules to email. JCF, Sestafoni, Nicoladze, Ferroloi Plant, and Robley Holdings, 2004, was a case when they said that sending by facsimile is instant communication. So Tony Blair's brother, so Bill Blair, was involved in Thomas against BPE Solicitors, 2010, and he said the postal acceptance rule doesn't apply to contracts which are made through emails. There's a Singaporean case which agrees with this, Chi Kin Kiong and Digimall.com Private Limited, 2004. So these are regulations about trading by the internet. There was the Electronic Commerce EC regulation, 11.2, that's a European Union regulation, which governs all this. So English contract law has not yet had a case which clearly solves the rules about instantaneous communication. There are cases show the direction of travel, such as Allianz Insurance Company Egypt against Aegon Insurance Company, Société Anonyme. So technology has moved on. All right, so that's probably enough for this video.